The following radio program is for informational purposes only and is neither specific nor tailored financial advice to any individual. It is not intended as an offer or solicitation for the purchase or sale of any financial instrument. Always do your own due diligence and consult a financial advisor before making any investments. Investing involves risk, which can result in the loss of any or all principal. Peter Weitz is a registered investment advisor with Fusion Analytics Investment Partners, LLC, an SEC-registered investment advisor, as well as a registered rep with Fusion Analytics Securities, LLC, a FINRA registered broker-dealer and SIPC member. All views expressed in this program are those of the host or guests and do not reflect the opinions of Fusion Analytics Investment Partners nor its affiliates. Your investments. How secure are you that they are secure? Do you want to know more about investing, retirement, and moving to the next level in business? Welcome to In Black and Weitz, featuring host Peter Weitz. Our program will answer all of the questions about your future and so much more. It's all about smart business and smarter investing. Now, here is your host, Peter Weitz.
Hi, good morning. Welcome back to the program, and thanks for joining us. We have a very interesting show, and we're going to jump right into it right away. Today we're going to talk about data breaches, and specifically we're going to get some tips and some very useful information as to how we can further protect ourselves and our companies and our potential clients and customer information going forward. So I'm joined today by two very distinguished people and attorneys at the law firm of Steptoe Johnson, and I'm going to introduce both of them real briefly, and then we're going to get right into it. I've already gotten a couple of questions from listeners, so I imagine we got a lot of topics to cover, but I'm joined this morning by Stewart Baker and Jason Weinstein, both partners at the law firm of Steptoe Johnson. Stewart's been at the firm for 3.5 years. Came to the firm following 3.5 years at the Department of Homeland Security as its first assistant secretary for policy. At Homeland Security, he created and staffed the 250-person policy directorate, which was responsible for international affairs, strategic planning, relationships, law enforcement, and public advisory work. And essentially, he was working with travel data, privacy, visa waivers, and so forth, but all related to secure information. And Mr. Weinstein is also a partner in the Steptoe's Washington, D.C. office, and he concentrates his practice on criminal defense and privacy and data security matters. He was former Deputy Assistant General of the U.S. Department of Justice Criminal Division, and he was a lead prosecutor for many years. And his tenure at the DOJ, he supervised a computer crime and intellectual property section, organized crime, and human rights and special prosecutions section at DOJ. So both of my guests today are very distinguished in their field, and I think it's something that's really burgeoning as a field as we hear more about what's going on in the world, and we'll get into it when we hear things about like Target losing, having data violations and compromising our personal information. But gentlemen, welcome to the program.
Thank you for having us.
And Stewart, I want to start out right out of the block, and just can you give me a brief overview on the primary types of threats that companies are facing today?
Yeah, one part of my bio that I haven't emphasized until recently is I was also general counsel of the National Security Agency, about which nobody cared until about a year ago. But in that job and also at DHS, I spent a lot of time worrying about hackers who were breaking into networks. And to my mind, the first thing you really need to ask yourself is, who's likely to want to break into my network? And I would put the likely candidates into three categories. There are state actors, people working for the People's Liberation Army or the Russian government or the French government, for that matter, who might want to steal your secrets for reasons of state or to help some state-owned enterprise inside their government. And it's surprising how often people are victimized by state actors because the state actors feel that they are really immune from any consequences. But for many of us, the bigger worry is people who are trying to steal something of value from us, usually money, trying to compromise our credit card information or our electronic banking information to steal something. So that you've got just ordinary crooks who have found that this is a growth business. And then finally, you've got a whole bunch of people who used to call themselves anonymous or lulzsec, who are motivated largely by a desire to cause pain, often to people that they've decided are out of step with their political views, whether it's the recording industry or government officials. Almost anybody can fall foul of them, and they are mostly in the business of stealing your information in the hopes of embarrassing you in public. And so everybody could fall foul of that last category, and practically everybody's at risk from financial criminals. Fewer people, though a surprisingly large number of them, have to worry about state-sponsored attacks.
And I know both of you have significant government experience. Jason, just comment real quickly on how your experience at the Department of Justice has really helped you in this field.
Well, if I've taken anything away from my government experience, it's that law enforcement in this area is outgunned. The agents and the prosecutors that we have at DOJ and in the U.S. Attorney's offices around the country and in the FBI and Secret Service who would try to investigate and bring these cases criminally are the best of the best. There just aren't nearly enough of them, and there will never really be enough of them. These cases are incredibly challenging. They're incredibly time-consuming to bring. They often involve they require the cooperation of a foreign law enforcement, sometimes in countries that aren't so inclined to be cooperative. And so it makes it very difficult to bring these cases quickly enough or in large enough numbers to have a deterrent impact. So one of the reasons why, Stewart mentioned the for-profit hackers, one of the reasons why people engage in this activity for profit is because they perceive it to be low risk and high reward. And so we're never going to be able to investigate and prosecute our way out of this problem, and that puts the burden on companies to do the best they can to protect themselves. So after years of from my law enforcement days, helping oversee investigations of breaches after they occur, a lot of the attention that Stewart and I and our partner Mike Vatis have devoted to this has been trying to help companies even before they get breached to try to reduce the risk of an attack and then put themselves in the best possible position to deal with an attack if it occurs.
Yeah, and I think it's interesting as well is that, we're essentially, I look at it, we're almost a cashless society. And everything that we do, we have debit cards, credit cards, internet, smartphones. Everything we do is essentially based off of a computer. And I'd imagine that, when you talked about we're being outgunned, we're dealing with a situation where we've got to have high-level computer programming people that actually understand how to create this net, if you will.
Well, that's right. And, it's not just personal financial information, although that tends to get the most press because it affects consumers and members of the public. But it's also theft of intellectual property. It could be a trade secret or it could be some other proprietary business information. There are hedge funds that, have been attacked and had trading algorithms compromised. I mean, there is all kinds of proprietary business information that companies need to survive that, if stolen, could compromise the very future of the company.
It's also true that the skills that it takes to build these systems are not necessarily the same skills that it takes to secure them. The guys who are designing the programs want them to work, and they are they're willing to stay up all night to make the program work. They're not thinking about ways that it can be broken, and so you almost need a separate skill set or sort of like a proofreader for security who is thinking all the time what could go wrong and how can I fix that.
Well, the reality is there are new hackers graduating from high school, or maybe I should say middle school or preschool, every year in Eastern Europe, and they're cranking out hackers faster than we can crank out security people. So I think it's going to be a problem that we face every minute of every day going forward.
Yeah, and we'll touch this as the subject for a different day, but it's a sad state of affairs when those smart people are actually using it in the wrong way when they could actually be putting it to good use. But another question that I guess comes up, and I sort of want to build this how the problem exists, and then the things that you think about and the things you help your clients with to prevent. But in my thoughts, changing the level of awareness among executives, I don't think is really as high up on the list as it should be.
I think that's right. Even though, Target lost its CEO, he lost his job largely because of his response to and the company's response to a serious breach. But the fact is, in many cases, the CEO doesn't feel technically competent to judge how good a job his security folks are doing, and therefore just hopes that he's hired the best people and that they're doing a good job. One of the things that we struggle with is how do you teach CEOs the kinds of skills that they need to deal with these problems. And again, I think it begins by saying, who wants my data? And then asking, and what tools are they using, and how well are our security measures able to thwart those tools? And if you push the question from who wants to steal my data and what are they going to do with it, I think that's something CEOs ought to feel comfortable asking about and getting information about.
And I was going to say, Peter, just to build on that, when I interviewed for this job, one of the questions that Stewart asked me when he interviewed me was, how are you going to get people to pay to fix a problem they haven't experienced yet? And what he meant by that was, you've got executives and directors who haven't experienced the Target-like nightmare yet, and you're going to come in and try to convince them that they need to spend money to try to reduce the risk or to mitigate the risk. And how are you going to do that? And it reflects the fact that is exactly what you said, that there isn't enough of a recognition that you need to be engaged on this, even if you're not a tech person. And this Stewart's answer just, I think, highlighted, you don't have to be a technology person to understand the risk and to assess the risk and to respond to it. And the risks of, the costs of not responding to that risk are too great. Stewart mentioned the Target CEO. You've got shareholder suits coming faster and faster now against directors and officers claiming that they breached their duty by not providing adequate cybersecurity in the wake of an attack. And as I mentioned before, in some cases, the risk of an attack threatens the entire enterprise. So the costs of not acting in advance are just too great. And so I think that Target hopefully is a wake-up call, but not enough people are awake and understand the need to deal with this now.
Yeah, and that's interesting. And particularly, I would imagine that a drop in shareholder price is certainly going to be a big wake-up call for the CEOs that are out there.
And it's not just the drop in shareholder price, but what follows. Because every time you have an attack and you have a drop in the share price, you're going to have litigation. And I think any director understands the consequences of shareholder litigation.
Right. It's almost as if you're saying you're an insurance policy.
Yes, you in an odd way. The banks will often insure the customers against loss, but they will turn around and pass all those costs on to the merchant, and that's what's happening to Target. A lot of these lawsuits are banks saying it cost us a lot of money to replace everybody's card, and you're going to pay for it.
Right, and that's interesting. We're going to take a quick break, gentlemen. When we get back, I want to talk about your concept of the blame the victim environment. We're going to do that in just a minute. You're listening to the In Black and Weitz radio program on the Voice America Business Network.
When it comes to business, you'll find the experts here. Voice America Business Network.
ERISA 408B2, fiduciary standards, safe harbor, fidelity bonds, record keepers, discrimination testing. I am so confused.
Does your 401k plan have more questions than answers? Peter Weitz and his team of 401k experts have a solution. Their on-site service model distinguishes them from other service providers, and they are specialists in 401k costs, regulations, and compliance. If your 401k plan has more questions than answers, then contact Peter at 877-945-2888 or email him at peter@inblackandweitz.com.
Climbing Mount Everest is an amazing feat, and many have died trying to do so. However, more people have died descending Mount Everest than in reaching the summit. Part of the problem may be that people are so focused on reaching their objective that they fail to plan appropriately for what they will do or should be prepared for afterward. Similarly, people are so focused on saving for retirement and reaching retirement that they fail to plan appropriately for what they will encounter once they have actually retired. With 1 out of every 4 65-year-olds today living past the age of 90, you may be retired longer than you are actually working. Have you devised a plan, process, and discipline to ensure that you will not run out of money? If you are not sure what to do, then simply contact Peter Weitz and his retirement team at Fusion Analytics. We help manage human emotions using 3 proprietary investment techniques. Our job is to evaluate the forces that the typical investor can't see so that wealth is preserved and not lost. Find out more at inblackandweitz.com. Weitz is spelled W-E-I-T-Z. Email Peter at inblackandweitz.com. In Black and Weitz, we win by not losing.
When it comes to business, you'll find the experts here. Voice America Business Network.
You are listening to In Black and Weitz. To reach Peter Weitz or his guest today, please call 1-866-472-5790. That's 1-866-472-5790. You may also send an email to peter@inblackandweitz.com. Weitz is spelled W-E-I-T-Z. Email Peter at inblackandweitz.com. Now, back to this week's program.
Hi, thanks. Welcome back to the program. I'm joined today by Stewart Baker and Jason Weinstein of the law firm Steptoe Johnson, and they are both experts in cybersecurity. And as Stewart mentioned in the beginning of the show, he is the former general counsel of National Security Agency. So as you can imagine, his schedule is extremely busy. And while I have him available to you on the program, I did get a question that I'd like to ask him before he has to head to a different appointment. But Stewart, we did get a question regarding the protection of email and cell phones. And I'm wondering if from a government perspective, what's going on from a legislative arm, or if there's any sort of protections that are coming down the pike.
So there's plenty of protection in the law against the government just randomly picking up your email, although that if they have probable cause, they can certainly get it. But I think the bigger concern is people who don't care what the law is, and there I think it's only technical measures that can protect you. There are lots of products that give you that allow you to encrypt your messages while they're moving across the internet, because that's the security concern that many people had and still have. But to tell the truth, my biggest worry these days is that hackers will find my email where it's stored and steal it, and encryption over the internet doesn't help you there. So one of the recommendations I make for people who are handling sensitive data, and especially where both sides of the transaction understand the sensitivity, is to use password-protected, encrypted files, a doc file or a PDF file. You can put a password on that, and the encryption is pretty good, and it stays encrypted even after you've opened it and closed it, so that if somebody steals it, they're less likely to get the most intimate details. There is also something I have not yet tried. I have a lot of faith, actually, in the protections that Google and Microsoft provide to their webmail systems, although I would still encrypt the most sensitive stuff at rest. But Google has recently announced a Chrome extension that will encrypt the message even as it's sitting on the server, which is counter to their business interest, but which they have put in place in order to provide additional security in the event of a hack or, frankly, a government court order. So that's something to take a close look at. On the cell phone side, and one last point on that, I have switched to a situation in which I have a single old laptop, which I have nuked and reinstalled a Linux system on, and I use that for one thing and one thing only, which is my electronic banking. And I don't use it to surf the net or to go anywhere else on the theory that that's the best way to protect my financial transactions. Phones, much more difficult problem, far more difficult and much more fluid. Every time we check, we say, yes, 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 I accept for an app. We run the risk that the app is going to start stealing our information. Most enterprises adopt or are looking at solutions that essentially wall off your business applications, your business email from the rest of the phone. That's clearly our best hope, because we can't count on consumers never to install an app that isn't properly vetted. And so you need a way to prevent that app from getting access to the business data. I'm not completely convinced that we have a solution there, but that's the direction in which some of the security providers are moving. If you're not satisfied with that, you really need a phone for your personal use and a phone for business. And I hate to say that, but that probably is your best security option today.
And are you finding that with your clients that you're having to educate them more in this regard so that they're aware that it's a much bigger issue than is perceived in the marketplace?
I am seeing that, although there's been a real sea change, especially in the financial industry. Investment bankers who just used to care how fast you could get them the answer now want to know how good is your security. If you do something that they don't do, if you carry the same phone to on a business trip to China that you use in the United States, you will lose their business, and that is changing the climate around security.
Interesting. And so, we talked a little bit about what we've seen in the public with the Target CEO losing his job, and how companies have to become more aware, and how it's important for you to educate CEOs and your clients of how important security of information is. But what about, how do you worry about, or how do you protect what's going on the other side? I mean, how are you thinking ahead about what attackers are potentially going to do to your clients?
Jason?
Well, as Stewart said, part of what you have to do is figure out what types of attackers might be interested in from each client, because then the nature of the threat that faces the client in the financial sector or the healthcare sector or the energy sector is going to be different. So a lot of what the advice that you give to clients in this space can't be cookie cutter. There's certainly some things that are common to the advice that you give to clients in any industry, companies of any size. But you have to really take a good look, and law firms and forensics firms, I think, both do this well. Look at the nature of the threat that the client's facing and tailor the advice to that threat.
And now take it one step further. So now you've identified. So now you're on the front end, and you're identifying, what you could do to mitigate some of this risk. But how do you litigate against someone, against shareholder suits or consumer class actions? I mean, what would be the typical defense?
Well, a lot of the early wave of these cases, you have to sort of break down the type of litigation. So there have been several different types of litigation that companies have faced in this, as you referred to it earlier, as a blame the victim environment, which I think is right on the money. There's consumer class actions. If you're a retailer or Target or Neiman Marcus, there are multiple class action suits filed. I think in Target's case, there are something like 100 different class actions filed against it by consumers. Then you've got suits by shareholders. Then Stewart alluded before to the fact that you might be sued by the banks for losses involved in replacing cards. And then in addition to litigation, you've got investigations by regulators. You've got the FTC. You've got, if you're a healthcare institution, you've got HHS to worry about. If you're a public company, increasingly you have to worry about the SEC. And then I think every state AG in every state I'm aware of has an office or has personnel devoted to investigating data breaches. So you find yourself having to defend on multiple fronts at the same time. And there seems to be this. Go ahead, Peter.
No, go ahead. I have a follow-up question, but I can wait.
Well, I was going to say there seems to be this presumption, and it's frustrating for companies that we talk to among the public and even among members of Congress in the wake of these high-profile breaches, that if a company gets breached, it must be that company's fault. And that's not true, and it's not fair, and it's not realistic. And it's almost like instead of being guilty until proven innocent, these companies are negligent until proven reasonable. And so a lot of the advice that we give to companies is to understand that the risk of a breach is the same as risk of litigation, and that the steps they take proactively can not only reduce the risk of breach, but ideally put them in the strongest possible position to defend against litigation from whatever source it comes, and to defend against the investigations from whatever regulator brings them. Because the essence of these lawsuits and these investigations is the allegation that the company did not have reasonable cybersecurity. Now, no one knows, by the way, what reasonable cybersecurity is, because there isn't some federal standards that defines it. But if you can point to the steps that you took in advance of a breach to harden your network as much as it can be hardened and to address the risks that anyone reasonably could address, then you put yourself in the best possible position to defend against those lawsuits. Some of the consumer lawsuits, companies have had success in getting them dismissed on standing grounds. That is the legal argument that if a victim hasn't actually suffered an injury, they don't have a right to bring a lawsuit. But plaintiffs' lawyers they adapt, and when they lose, they go to school on each other's mistakes, and they come up with other theories that get them over that hurdle. So I think it's a mistake to just assume that you'll be able to get rid of these lawsuits on a motion to dismiss, and in fact, they're going to be expensive to defend, and if you settle them, they're going to be very expensive to settle.
Yeah, and I think that's the interesting point, is that there's got to be some reasonable measure of what you've done, because corporations are being asked to protect against something that they don't know exists.
Well, and that they, in some cases, you can't protect against. I mean, the state actors, the really sophisticated Eastern European hackers are really good. And that's not to say you can't protect against all risks. There are certainly the opportunistic hacker. The hacker is going to take advantage of the company's unforced errors. You can lock things down, and you can do a really good job protecting against those hackers. But the reality is, if someone's determined to get into your system, they're getting into your system. And in that situation, to blame the company when a really sophisticated hacker overcomes millions of dollars of investments in cybersecurity to get into the company's network and wreaks havoc and steals information, it's horrible, and it's regrettable for the people who are victimized by the breach. But the company was a victim too, and to hold the company responsible, either to the exclusion of or greater than others, is unfair. I mean, I often say that class action litigation for data breaches is like ambulance chasing for the 21st century. And instead of literally chasing after ambulances, you have plaintiffs' lawyers that scour the web for reports of breaches and then race each other to the courthouse. I think in Target's case, there were several lawsuits filed within hours of the breach report. It's like the complaint is some kind of Mad Lib on the lawyer's screen, and he just fills in the name and the date of the breach and then runs to the courthouse with it. So if you get breached, you are going to get sued, and you are very likely going to get investigated. And so everything you do before and certainly after the breach has to be done with that in mind.
Yeah, and that's an interesting point. We're going to take a quick break. When we get back, I want to get a little bit of advice from you as to what companies can do to navigate through this. And then I want to get into a tool that you all have developed, and we're going to talk about that. We're going to do it in just a moment. You're listening to the In Black and Weitz radio program on Voice America Business.
From the boardroom to you, Voice America Business Network.
Climbing Mount Everest is an amazing feat, and many have died trying to do so. However, more people have died descending Mount Everest than in reaching the summit. Part of the problem may be that people are so focused on reaching their objective that they fail to plan appropriately for what they will do or should be prepared for afterward. Similarly, people are so focused on saving for retirement and reaching retirement that they fail to plan appropriately for what they will encounter once they have actually retired. With 1 out of every 4 65-year-olds today living past the age of 90, you may be retired longer than you are actually working. Have you devised a plan, process, and discipline to ensure that you will not run out of money? If you are not sure what to do, then simply contact Peter Weitz and his retirement team at Fusion Analytics. We help manage human emotions using 3 proprietary investment techniques. Our job is to evaluate the forces that the typical investor can't see so that wealth is preserved and not lost. Find out more at inblackandweitz.com. Weitz is spelled W-E-I-T-Z. Email Peter at inblackandweitz.com. In Black and Weitz, we win by not losing.
ERISA 408B2, fiduciary standards, safe harbor, fidelity bonds, record keepers, discrimination testing. I am so confused.
Does your 401k plan have more questions than answers? Peter Weitz and his team of 401k experts have a solution. Their on-site service model distinguishes them from other service providers, and they are specialists in 401k costs, regulations, and compliance. If your 401k plan has more questions than answers, then contact Peter at 877-945-2888 or email him at peter@inblackandweitz.com.
Voice America Business Network, the bottom line in business.
You are listening to In Black and Weitz. To reach Peter Weitz or his guest today, please call 1-866-472-5790. That's 1-866-472-5790. You may also send an email to peter@inblackandweitz.com. Weitz is spelled W-E-I-T-Z. Email Peter at inblackandweitz.com. Now, back to this week's program.
Hi, thanks. Welcome back to the program. I'm your host, Peter Weitz. We're talking with Jason Weinstein and Stewart Baker from Steptoe Johnson, and we've been talking about data breaches, and we've been getting a history of how it all occurs and things you can think about to protect yourself. But one point that was brought up to me during the break by Jason was this, is that it's not always the fault of the corporation that has the data breach. There are vendors and partners that businesses use that could be in violation themselves, which could impact us as a corporation. And I was wondering, Jason, if you could expand upon that.
Sure. You know, if we haven't scared or depressed people enough in the first part of the show, this
Right.
will certainly do it. Because it's not enough to worry about your own cybersecurity these days. You also have to worry about the cybersecurity practices of your business partners, your vendors, your suppliers, in some cases your clients, if you give them access to any part of your data or your network as part of your business arrangement, because your vendors or other third parties' network could be a launching pad for an attack on yours. So one of the things that's really important for companies to do is not only assess and evaluate their own cybersecurity in ways that we'll talk about in a little bit, but to do the same thing or to ensure that their vendors are doing the same thing for the vendors' network. And it's important to have contracts with your vendors, your other business partners, that require them to maintain reasonable cybersecurity, to indemnify you if there's an attack on your system as a result of an attack on theirs, to allow you to conduct audits to ensure that they're in compliance. This is a trust but verify situation, and to create an obligation on their part to notify you if they experience an incident, because that could be an early warning that you're about to experience one too. Target is, again, not to pick on Target, but it's hard not to do so. You know, they're a good example of this, because there are reports that one of the ways, if not the way, that their network was initially compromised was through their HVAC provider. And, you know, the other piece of that is that, and the HVAC provider might be a good example of this too, is that your vendors should have only access to those portions of the network that they really need to do their job. You know, there's no reason for the HVAC contractor to have access to anything other than the HVAC system, not to the payment system or the systems where data is stored. So it's really important to segregate your network to make sure that these business partners who you need to have some degree of access in order for your relationship to function, make sure that they only have access to what they really need.
And that's interesting. And, you know, I'm sitting here and I'm thinking about this. And, you know, one of the other things that we were talking about briefly is training. And, you know, I'm sitting in my office last week, and my assistant comes up to me and hands me an email from our client, and the email is her email address, and it says, "Can you please wire me $25,000 or wire my sister $25,000? She needs it for some purpose." And the email was exactly the right email, but I happen to know that my client doesn't have a sister. And so because of that, I was able to figure out that it was a bogus email, and it was someone trying to extract money. So we mentioned training, and it's just me knowing my client, but I'd imagine that employees at Target or some of these other corporations that have had issues, if they're more aware of what the situation is, it's going to help the problem.
Well, that's right. And what you've just described is what we call spear phishing. And so that's an email that is sent to you or to one of your employees that is designed to look legitimate to that person. You know, there's phishing that's broader, that might be sent to a whole group of employees at the same time, and there's spear phishing that's sent to an individual who's specifically being targeted, and there's some social engineering involved to make sure that the spear phishing email is one that would look legitimate to that person. And the goal, of course, as you alluded to, is to have you click on it or open the attachment, and when you do that, despite millions and millions of technological investments by the company, malware is now on the network, and the hackers are in the system, and they're going to find their way to the person with the most access, and they're going to start to steal information or steal data. And what that highlights is that cybersecurity is not just the IT department's problem, it's everybody's problem. Your employees are your first or last line of defense, depending on where you're standing, and they can either be a strength or a weakness. There are some studies that say that more than a third of cyber attacks are the result of employee negligence. And the reason that spear phishing emails like the one you described are sent, or the ones I get from someone pretending to be, my bank, where they misspell a word here or there, and some of them are actually higher quality than that. But the reason why that technique is used all the time is because it works. And so it's really important to train your employees, and this is a situation where, frankly, the government lags behind. When I was in the government, it wasn't uncommon for the cybersecurity training to be a video you watched for 30 minutes once a year, and then you had to answer some questions that my 3-year-old can answer about cybersecurity, whereas it really should be something that is a daily reminder. It's something that people think about all the time. And there are some companies that actually go to the length of designing fake spear phishing emails, and they send them to executives and employees at all levels of the company, designed to sort of increase or make sure that the employees and executives are sensitive to this all the time. And if you click on it, on the email, not realizing it's a spear phishing email, you're notified that, if this had been a real spear phishing email, that you would have probably compromised the system. So it's the kind of thing that is not meant to embarrass anybody, but it's meant to raise everybody's level of awareness all the time.
Yeah, and that's interesting. And so, now, all right, so the training, I guess, leads me to my next question, which would be, what advice would you give to companies to kind of navigate through this environment? And, as we talked about at the break, Jason, I think you play really two roles here. I mean, yes, you're a practicing attorney and you're going to litigate these matters, but I almost think that you're really more important on the front end.
I actually think that's right. Look, we're a litigation firm and a firm that engages in regulatory defense, and our goal, if our clients are attacked and sued and investigated, is to defend them vigorously. But what we'd like to try to do is put them in a situation where, number one, they can reduce the risk of an attack in the first place, and number two, they can take steps in advance of a breach to make the defense in the litigation and the investigations that much easier and that much more likely to succeed because of steps they took in advance. And so a lot of our advice is to try to get us involved at the front end. And we do that in a number of ways. First, we do security assessments, some that involve technical, legal, and administrative aspects in advance of a breach. And the other thing that we do is we work with companies to develop, or if they've an incident response plan, or if they have one, to review it and to test it. In other words, to simulate a breach event before you actually have a breach event, to make sure that your response plan works the way you want it to and your people perform the way you want them to. And one of the reasons why you want a lawyer to do that, ideally a lawyer and a forensics expert working together, but the reason you want it to be done under the auspices of the lawyer is so that it's privileged, because you don't want the last thing you want is the steps you've taken or the assessment you've done or the results of that assessment to come back and be used against you later in litigation after an incident. So a lot of our the role that we can play in advance is in some ways, as you alluded to, I think more important than the role we can play afterwards.
Yeah, and that's interesting. And then now all of a sudden, and it's the irony of this, Jason, is that, so now information becomes privileged and it's up to you to protect that information as well.
That's right. That's exactly right. And, I often say the best defense to your litigation later is to be proactive now. And the best way you can do that is to get a lawyer, outside counsel, outside forensic expert, and to have them look at certain core areas. These are sort of the core areas of an assessment. Look at things like your privacy notices and practices. One of the easiest ways for a regulator to come after you is if you tell the public you're doing one thing with your information and in fact you do something different. To look at training, we just talked about training, to make sure that you've got the best cybersecurity-related training measures appropriate to your company and its risk. To have someone at a forensics firm look at all your technical measures, your firewalls, your passwords, access restrictions, making sure you're purging old accounts when an employee leaves the company, because that eliminates one pathway someone can use to get into your network. Making sure you're using encryption, that you have secure backups, that you're logging all the activity on the network, so if you're attacked, the event could be recreated. Making sure you destroy your information when you don't need it anymore. The easiest way to prevent someone from stealing something is not to have it. And so if you don't need it anymore, we counsel companies to have an aggressively enforced records retention and destruction policy, looking at contracts with your business partners like we talked about before, and making sure you have measures in place to deal with insider threats. We focused a lot on the show today about hackers coming in from the outside, but companies also have to worry about employees who go rogue and steal things from the inside. And then last but absolutely not least, we look at, as I said, the incident response plan, and we encourage companies, even if they don't want to do a full-blown assessment, to at a minimum test the plan. To do a breach simulation. Breach is a crisis, and people don't often do their best thinking in a crisis. And the best way you can find out if your plan works the way you drew it up and your people perform the way you want them to is to actually simulate the event. And it's a tremendous exercise, and it's tremendously valuable to the company because you find out what you need to fix. And as one of my colleagues likes to say, no plan survives contact with the enemy. And if you test it out, then you make sure that when there's a real event, the plan will work and your people will work.
And are you finding also that, or do you ever recommend that companies have somebody on board that's just trained to try to hack into the system to see if it's unhackable?
There are a lot of people who companies that have that, or that they engage outside experts to do it. To do what you're describing is often called penetration testing, and I think it's a valuable function. Whether someone needs to have someone on board to do that all the time, or you make it part of a regular assessment to have outside experts try to do that, I think it can be a very valuable service.
And it's so. In light of all this, I should say, you've put together this toolkit, and I want to talk about it. We're going to end up taking a break in between talking about it, but I want to get into sort of what it is and why it's useful and why it's beneficial to your clients and potential clients.
Sure. So, we talked before about a couple of breaks ago about the need for executives and directors to be engaged, and when I talk to executives and directors all the time, even those that know they need to become more engaged in these issues, a lot of them say they don't know where to start, either because it's overwhelming, which it is, or because they're not technical people, which, as I said before, they don't have to be. But we designed the toolkit in part to tell those folks where to start and to try to make something that can be completely overwhelming a little less so. And so the toolkit is designed to give practical guidance to help companies begin to evaluate their level of preparedness for a breach and to put together their response plan and to really start to think about what they're going to do before and immediately after a breach to put themselves in the best possible position to withstand this blame the victim environment that we talked about before.
What are some of the things that they think about or that you think about when they do this plan?
Well, we broke the toolkit down into sort of before and after. And the before part includes a lot of the things that I just mentioned that I rattled off as core elements of a privacy or security assessment. And we have brief descriptions of some of those core elements, a lot of which I just mentioned, network security, contracts with vendors, employee training, records retention, your privacy notices, insurance coverage, assessing whether you need cybersecurity insurance, mapping your data, evaluating your technical measures, and of course having an incident response plan and testing it. So we have that as the checklist of things that you should be doing now before an incident occurs. And then in the after section, we've got a checklist of what we think are the core elements of an incident response plan and a strategy for incident response. And then we also include, because there are 51 separate breach notification laws that companies may have to deal with, 47 state laws and 4 territories, not to mention foreign laws that companies have to grapple with. One of the challenging issues when a company is breached is knowing making sure it's complying with its legal obligations to notify consumers or government authorities. So we've got a roadmap that helps you understand and at a glance what the various features of those laws are, because they often conflict.
And that's interesting. We're going to take a quick break. When we come back, I got a couple questions to tie this all up. You're listening to the In Black and Weitz radio program on Voice America Business.
Voice America Business Network, the bottom line in business.
ERISA 408B2, fiduciary standards, safe harbor, fidelity bonds, record keepers, discrimination testing. I am so confused.
Does your 401k plan have more questions than answers? Peter Weitz and his team of 401k experts have a solution. Their on-site service model distinguishes them from other service providers, and they are specialists in 401k costs, regulations, and compliance. If your 401k plan has more questions than answers, then contact Peter at 877-945-2888 or email him at peter@inblackandweitz.com.
Climbing Mount Everest is an amazing feat, and many have died trying to do so. However, more people have died descending Mount Everest than in reaching the summit. Part of the problem may be that people are so focused on reaching their objective that they fail to plan appropriately for what they will do or should be prepared for afterward. Similarly, people are so focused on saving for retirement and reaching retirement that they fail to plan appropriately for what they will encounter once they have actually retired. With 1 out of every 4 65-year-olds today living past the age of 90, you may be retired longer than you are actually working. Have you devised a plan, process, and discipline to ensure that you will not run out of money? If you are not sure what to do, then simply contact Peter Weitz and his retirement team at Fusion Analytics. We help manage human emotions using 3 proprietary investment techniques. Our job is to evaluate the forces that the typical investor can't see so that wealth is preserved and not lost. Find out more at inblackandweitz.com. Weitz is spelled W-E-I-T-Z. Email Peter at inblackandweitz.com. In Black and Weitz, we win by not losing.
The business community's first choice in Internet Talk Radio. Voice America Business Network.
You are listening to In Black and Weitz. To reach Peter Weitz or his guest today, please call 1-866-472-5790. That's 1-866-472-5790. You may also send an email to peter@inblackandweitz.com. Weitz is spelled W-E-I-T-Z. Email Peter at inblackandweitz.com. Now, back to this week's program.
Hi, thanks. Welcome back to the program. We're joined today by Jason Weinstein, a partner in the law firm of Steptoe Johnson in Washington, D.C. And we've spent the vast majority of the show talking about data breaches and how companies can protect themselves better to avoid them in the future. And one of the things that, Jason, you mentioned prior to the break, and I wanted to follow up on it, was you started to mention about how there's all these different laws that are out there, and I guess I'm curious as to how you would actually navigate what law applies to what data breach.
Well, one of the things that we do proactively before a breach occurs is help the company figure out where their data is and where their customers are, because that's going to help you figure out, at least preemptively, what data security laws apply, whether they're domestic or foreign. And it's important to know, you'd be surprised how many companies in the wake of an incident use the incident as the excuse to figure out where their data is and don't know the answer. So we try to get that answer in advance. And then once the compromise, the breach occurs, and we can see what systems and what data was compromised, we can assess relatively quickly what laws apply. And, as you and I were talking about at the break, it's not just U.S. law that applies increasingly. It's foreign law, too. If you have a company that does business overseas or has customers from overseas, which is, a huge percentage of the companies in the world today, you may have to grapple not just with your compliance obligations here in the U.S., but overseas. And they're complicated enough here in the U.S. I mean, as I said before, there are 47 states, and plus D.C., Guam, Puerto Rico, and the Virgin Islands that all have their own breach notification law, and in many significant ways those laws are in conflict with each other, or at least they impose different types of requirements. And notification is one of the challenges that companies really have in the wake of a breach, and it's something that you see companies really struggle with. Target had its own challenges with notification, and a lot of other companies struggle with it too. And one of the problems is that you have legal obligations, or you otherwise feel an obligation to your consumers to say something to the public about the incident at a time when you don't really know what happened, or you don't know the full picture of what happened. And so it's really important to have a notification strategy worked out in advance, and that's part of what we do in a breach simulation. Is we have corporate communications people at the table, executives, lawyers, IT people in corporate communications, all the people involved in a response team, and we simulate these challenging situations where you're making public statements and you're worried about making sure they're accurate in the face of imperfect information. It's really, really important for companies to be accurate. Even if you don't know the full scope of what happened, you have to be right. Whatever you say has to be right. Nothing undermines a company's reputation more than the breach itself than having to correct public statements about the breach. And so it really is a compliance challenge. And then when you layer on top of that the foreign laws, it's really a real problem. The reality is, and I probably lose my card in the union for saying this, the fact that you've got a very difficult compliance environment like this is only good for lawyers like me who advise companies on breach response. It's not good for the companies, and it's not good for the consumers. And it really adds insult to injury that companies that are already dealing with in the aftermath of a breach. They're dealing with the cost of the breach and the reputational harm and the future litigation expenses. And on top of that, they have to deal with this compliance environment that looks like a maze in a book of mazes. And it would be, if Congress were to take steps, and there have been federal breach notification laws that have floated around for years without action, if Congress were to take action to actually simplify that regulatory landscape, and that would be one small step that would make a big difference to companies and make breach response a little bit less complicated than it is today.
And what about like massive e-commerce companies that cross jurisdictional lines as a business, like, I don't want to throw out any names, but like an Amazon or something like that. I mean, how do they decide, or how do they know what laws are going to apply to them?
Well, as I said before, it's not easy, and a lot of it depends on knowing where the data is and whose data was compromised. If you've got data from consumers in 15 different countries, then you're going to have a much more difficult situation than if data from people in one state, which, to use a sort of absurd hypothetical,
right.
Unrealistic one. It really is going to be a function of where the data is and whose data it was. But you're right that companies that do business all over the world are going to have a significant compliance challenge. Even if the laws were streamlined in the U.S., they've got to worry about laws in other countries that are often either more stringent or certainly different than the laws in the U.S. So that's an often overlooked but really serious part of breach response, and that's another reason why, not to put in a plug for the lawyers, but that's another reason why you need lawyers to be spearheading the response effort.
Well, and as I'm thinking about this, and I'm thinking about, obviously you're an attorney and this is what you do, you're going to end up saving the company a lot more money by being upfront as to what they want to do than on the back end. Because if I think about companies across all these different countries and cross-jurisdictional issues, these lawsuits could go on forever and ever.
Yeah, I say all the time, Stewart and Michael get sick of hearing me say it, that not only is an ounce of prevention worth a pound of cure, it's a hell of a lot less expensive. And taking proactive steps to put yourself in the strongest possible position to reduce your risk of a breach and withstand litigation and investigations that will follow a breach. As Stewart alluded to when he interviewed me for the job, paying for a problem you haven't experienced yet, you're going to pay a lot less to deal with that problem in advance than to deal with all the consequences after it occurs.
And that's interesting. And, with that, I really want to thank you, Jason, for being on the program this week. It's a topic that we could talk hours and hours and hours on end for. And I think we barely scratched the surface as to where it's going to go as an issue.
I appreciate you having me on, and happy to come back and talk about it any time. As you said, it's an issue that we could talk about for hours. I would like to, the people who run the place here would like me to mention where you could find the toolkit. It's a free resource that's available to anybody, and we hope it'll be helpful to anyone who uses it as a way to get started in trying to do some of the proactive measures that I talked about. It can be found at steptoe.com/data breach, one word.
and I appreciate you throwing that out there. You took the wind out of my sail. I was going to be happy to plug you, but yeah, I'm also going to be posting that that link on my blog as well. So for the listeners that want to hit me on my blog, as usual, you'll find it. It'll direct you right over to the Steptoe webpage. Again, I guess the best way to describe it, and I wrote this down, I'm going to make sure I remember it, an ounce of prevention is worth more than a pound of problem. And I think that really sums up why you would want to engage a firm like a Steptoe in an issue like this on the front end to avoid what would happen to you on the back end. But again, Jason, thanks so much for being on the program. I really appreciate it. And next week, I've got my, for those that listened several months ago, a dear friend of mine who was held hostage in China, Chip Starnes, he was held in his factory by his Chinese workers when he was moving his business from China to India, is going to come back on the program. He's actually going to talk about what it's like doing business in India versus doing business in China. And I know all the listeners that listened to him the first time were fascinated by his story of being held as a hostage. Will certainly like what he hears, or what you're going to hear about what he says about India. But again, Jason Weinstein, Steptoe Johnson, thank you for being on the program. You're listening to the In Black and Weitz radio program on Voice America Business. Make it a great week.
Thank you again for tuning in to In Black and Weitz. Please join your host, Peter Weitz, again next Tuesday at 10 a.m. Eastern Time and 7 a.m. Pacific Time for another edition of the program on the Voice America Business Channel. Have a safe week.